appeal in the matter of Ignite International Brands UK Ltd and others, and Cooper and others.
Yes, Ms Scotland.
Good morning, my lords. I appear for the appellant in this matter. My learned friend Mr Hitchins appears for the respondents. Mr Hitchins also appeared for the respondents and
Yes.
the claimants in the first instance hearing as well.
This is your debut.
It is, my lord.
Right. Now, I see, unfortunately, that we can see ourselves, but not your client. I understand that there's been some difficulty with the CVP.
Yes, the prison told us late yesterday afternoon, only about 4:30 or 5 o'clock, in a single line email, all caps, no punctuation, that it was, and I quote, not in the diary, end quote. We've chased them this morning. The prison claims that it was never booked properly. I'm not entirely sure what that means by the court, although personally I would suggest that this is the prison's fault rather than anyone else. And they've also said that, I'm afraid, my lord, there is now no space in the prison in their CVP booth, so they can't just drag him in.
Well, I'm obviously sorry to hear that from the point of view of Mr Cooper. And I certainly don't want to get into an inquest about how it came about, but unless it causes you any difficulty, I think we had better proceed, because clearly this has been awaiting a decision.
Well, I have instructions from my client to push on, that he wishes to push on if your lordships are willing to let it go that way.
Thank you. Could I just say then, because it's a little bit disconcerting, that the television screens are on, but all that's on them is us. So we could perhaps cut the CVP link so that we don't have that any longer. Good. Thank you very much. All right, now we've obviously read everything and appreciate that the issue here is whether the judge was wrong not to suspend your client's sentence. But we see that there are two grounds of appeal, and really wanted to just clear some ground and see whether they really are two grounds of appeal or whether it's one, as it were, one big point. Does the Turk case really stand for any principle, or are you really seeking to urge it in support of your first ground?
That is probably a better way of putting it, my lord. My learned friend in his skeleton does seek to make the point that there's no sort of freestanding, freshly minted point of law that emerges from Turk, and I can't disagree with him.
I mean, as I understand it, you're saying that Turk shows how the judge might, and you would go further and say should have, addressed this, but that's really a ground one argument, with Turk being seen as an example of what you say should have happened.
That is probably a better way of framing it, my lord. Turk is an example, perhaps with better put than a ground, and if your lordship is saying that 2 is really 1B, if I can put it like that.
Well, I'm not sure it's, at the moment, speaking for myself, I'm not sure it's anything.
Right.
But other than an illustration of a well-established principle, which is that there may come a point where for one reason or another, including because of the power of the mitigating or extenuating circumstances, a sentence of this kind ought to be suspended. But we obviously, it would be surprising if that proposition needed authority.
Turk is useful in my submission, my lord, because of, and notwithstanding my learned friend's disagreement on this point, other than what I accept is a significant distinction, which is that in Turk, the court at first instance had found, and as I understand it, this court agreed, that there had been no crystallised harm caused to the claimants.
Yes.
That obviously is different here, and I can't pretend that it's otherwise. Other than that, though, the circumstances in which Mr Turk found himself, except for the fact that it wasn't dealing with children, it was dealing with an elderly parent. Nonetheless, much of the other circumstance I suggest are on all fours, and perhaps therefore Turk fits better into the list that I put at paragraph 24 of my skeleton of examples of the kind of way in which I say Mr Justice Sweeting perhaps should have seen this.
Well, I don't need to prolong. I'm not interrupting your submissions because you haven't even got started, but I don't want to prolong it more than just simply to say this, that it's entirely up to you as to whether you wish to maintain Turk as a separate ground or whether you, in a sense, strike out ground 2 and put all your forensic muscle behind ground 1 with Turk appearing as part of that presentation. But it's entirely up to you.
I've already covered with you a certain amount of what I intended to cover with Turk in any case, my lord, so perhaps the best thing to do therefore is to roll it together.
We'll either have to say there's ground 1 and ground 2, or we'll have to say ground 2 has been run into ground 1 and we're faced with a single argument with all the points that you make in support of it.
In that case, my lord, and I take your point there, I'm going to take this forward with Turk as a support to ground 1 rather than as a freestanding ground in itself.
That's at least for our note is helpful. So now having performed that, I'll sit quietly and listen.
I'm obliged, my lord. Before I get really into ground 1, there's one preliminary point that I've discussed with my learned friend and that I seek to put before your lordships. There are 3 paragraphs in my learned friend's skeleton, paragraphs 18 to 20, that refer primarily and rely on a witness statement from the chief financial officer, who is now the chief financial officer. He was the financial controller of the claimants. This is his 3rd witness statement. It's in the supplementary bundle at 71 onwards, and in the 2nd supplementary bundle at 305 on are the exhibits to that statement. The problem with that section of the skeleton and those materials, which are in the bundle because they were in my learned friend's skeleton, not because we agree with them, is that those form the basis of an application to Mr Justice Sweeting to have them taken note of in the hearing in May. And the 4th order made by Mr Justice Sweeting on the 16th of May was that they couldn't. So my submission, to the extent that those papers might play any part in your lordship's considerations, is that they aren't something that myself or my learned friend should be making submissions on.
Right. Well,
because they've already been
to
pushed
reassure
out.
you to some extent. I mean, it used to be said, I don't know whether it any longer is, that applicants for committal didn't really have very much to say about sentence, and that once they had proved their case, it was really a matter for the court as to what to do about it. And I mean, here the extent of the issue between us is whether your client should be released but subject to a suspended sentence now, or whether he should serve his sentence until the end of September.
Yes.
Speaking for myself, I'm with all respect to Mr Hitchens, and I've read his document. It's not really, in my mind, up to them. And so I think your debate about this is with the court,
Yes.
and not Mr Hitchens. But we've obviously read what we've read, and very helpful it's been too. But I think it's really for you to make your case, and I wouldn't worry too much about anything that Mr Hitchens says, at least at this stage.
I'm obliged, my lord. In that case, I'll push straight on towards ground 1.
The ground.
The ground, indeed. I apologise, my lord. As your lordship has pointed out, this is really quite a narrow and specific appeal. There's no appeal, obviously, against the original contempt finding. That stands. That was in February. My client accepts, as he must, that he's been found to have committed 2 contempts, the first of which was that he failed either to deliver up the goods that are in question or to tell the claimants what had happened to them in the form of an affidavit. So there's a substantive problem there that my client had. He failed to do what the court ordered him to do. He was in contempt. That is that. The second contempt was not, as my predecessor, Mr Ubroy, sought to argue, a technical breach, but it was nonetheless a procedural breach in that the contempt itself was the failure to produce an affidavit on the back of the Diaz order, as Mr Dexter Dias KC had ordered. He completely failed to do that. The affidavit that was produced 3 calendar days before the sentencing hearing was accepted and noted by Mr Justice Sweeting, but it didn't change that failure that was a year old by then, or very nearly a year old. So that's contempt too, the failure to provide the affidavit that he was meant to. And he's been sentenced on those to 9 months running concurrently on each count. And again, the 9 months is not the subject of appeal. My client accepts, as he must, that that was a reasonable number under the circumstances to apply to him, a reasonable sentence. So this is all, as your lordship's indicated, about the question of whether suspension is justified and should have been justified. One final introductory point. On reflection, I've concluded that it was unfair of the grounds to suggest no consideration given by Mr Justice Sweeting to mitigation. It's evident that some was. I don't propose to pursue that. That would be wrong and foolish. I do say, however, that it wasn't adequate and that he doesn't appear to have considered it adequately, not simply failed to give reasons, as my learned friend has suggested. I accept too, as I must, that brevity in a situation like this is acceptable. That is clear from Lady Hale, as well, she wasn't then, she was Lady Justice Hale then, as what she said in Hale and Tanner. I can take you to that citation, but it's a well-known one. She used the words very briefly, indeed. She was giving guidance to busy county courts, as she called it, but I'm not suggesting that every circumstance needs more than a few words. Sometimes that, perhaps even usually, that will suffice. What I am suggesting is that where there's a question of suspending a sentence such as this in relation to mitigating circumstances, the authorities that I've quoted in, particularly in paragraph 24 of my skeleton, do make it clear that the propriety is to properly consider the nature of that mitigation, particularly where caring responsibilities are concerned. And in this respect, the case of Khan, which I've mentioned at paragraph 66, which is on page 63 of the authorities bundle, if your lordships need to look at it, is instructive.
Yes, by all means, take us to that. 63.
Page 63, yes, of the authorities bundle. This is a well-known citation, and I can't pretend that Mr Justice Sweeting didn't see it because he quoted it. Nonetheless, the words of it, I submit today, are relevant and important. In a case in which the last paragraph, the last sentence rather, is the important one, in a case in which nothing less than an order for committal can be justified, and I'm not suggesting that's not the situation here, the impact on others may provide a compelling reason to suspend its operation. Why do I mention that here? It's about the underlying facts of the matter, and I'll come back to this later. This isn't a situation where a single person is being cared for, or a couple of people are being cared for. I accept it's not a situation as it was in Turk, which you've already taken me to, my lord, where we were dealing with someone with a very serious an elderly person with serious illnesses. Instead, we're dealing with 8 children, the oldest of which is 14. The youngest of which is now, I think, around 22 months. For whom the contemnor was prime or sole, in one case, carer. Those, in my submission, are circumstances which require close consideration because of the extent of the impact, as said in paragraph 66, that inevitably will be dealt by a sentence like this. And none of this, again, my lords, I must stress, is to suggest that my client should not have been given a prison sentence, should not have been committed. This is solely dealing with the degree to which attention needs to be paid and should be seen to be paid, not only to the fact of these mitigating circumstances, but the nature of and extent of these mitigating circumstances. On this, a case that my learned friend mentions in his skeleton is in my submission relevant and instructive. This is the case of Sellers and Podstreshny. I'm not entirely sure of the pronunciation there. Which starts, it's the last case in the authorities bundle. It starts at page 239. But the paragraph I'm particularly interested in taking your lodgers to is the section that starts at paragraph 34 and runs through to paragraph 36. This is on pages 251 to 252. In one sense, Sellers isn't really on point for this situation.
What was this case about?
This case was, again, a contempt issue. Again, the contemnor had failed to follow court orders in a way that the court found was entirely deliberate and willful. The wrinkle here was that the contemnor was the carer for a very small child.
Sole carer.
Sole carer. Yes, my lord, I apologise. The reason I say it's not entirely on all fours, as my learned friend has suggested, that I think I understand draws the comparison, is because in that case, the court below inquired into what care would be available for the child and was reassured that care had been arranged. And this, I suggest, is clear in paragraphs, particularly paragraphs 35 and 36. So the issue before the court here was solely whether the fact of separation, rather than the circumstances of whether there would be an effect on care, was such as to justify suspension. Now, in this circumstance, as my learned friend points out in his skeleton, suspension wasn't justified. The sentence was considerably reduced, but suspension wasn't justified. I raise it now, though, to make that distinction and to say that even in a situation where care is all sorted and it's only about the fact of separation, this is still a point that required anxious consideration at first instance and then also to an extent by this court. In this situation, there's nothing to show, and I've seen nothing to show, and admittedly I wasn't in the court below, but I understand that nothing. While my learned friend Mr Ubroy made submissions about the fact of the 5 children and 3 stepchildren, I'm not aware of anything, and it's certainly not in the judgment either, of any information before Mr Justice Sweeting about what was actually going to happen to these 8 children.
Well, that was down to your client.
Well, I can't argue with that, my lord, but I mentioned it.
We can't take into account his failure as a mitigating factor.
That's true, my lord. Perhaps if I reframe that and say it's solely that, the circumstances of 8 children needing care are reasonably to be considered as larger and more wide-ranging than a single child needing care, even if that child is relatively young. And even if, as your lordship pointed out, the mother in Sellers was a sole carer rather than a primary carer in 7 of these 8 cases and a sole carer in the 8th.
Well, we've got paragraph 31, which I think accurately sets out the bare facts.
Yes.
And is there anything in your client's presentation to the judge that you want to take us to that shows what lies behind that? I think we've seen references in the medical report aspects of his family life, but where should we go within the bundle? I'm slightly hampered because the core bundle doesn't have an index. Where do
No, I see what you mean.
where do we go to find the underlying material that the judge had to create paragraph 31?
Of his sentencing judgment.
Yeah, his sentencing judgment, page 57.
If you'll give me a moment just to go to that. In the first supplementary bundle,
Yes.
at pages 161 onwards,
Yes. Well, we've got some. Are these the
this is
these are the court orders?
these are the court orders,
Yes.
which
One for his children, one for his stepchildren.
and they, my lord, the point of me bringing them to your attention is that they are the evidence of the extent of the caring responsibilities that my client has or had up until mid-May of this year.
But what we have here is we have a. I mean, you may want to take us to something else, and there's obviously reference to his personal circumstances in Dr. Pilgrim's report.
Yes.
But very often one sees arguments on a contempt appeal that this was all rushed. The situation here was precisely the opposite, namely that there was a hearing in July on the allegations of contempt. The judgment was not able to be delivered apparently until February, so half a year goes by.
Yes.
In that manner. And then another quarter of a year goes by before sentencing. And so Mr. Cooper had a huge opportunity, at least during the last quarter, to put forward his mitigation. And he was legally represented in the process. So if there is anything within these papers that you say fleshes out paragraph 31 of the judgment, because otherwise all the judge was presented with was that anybody would know that these children were going to be falling back on single mothers without his support, and that was going to be hard work. But is there anything more that you say that the judge was told that he ought to have reflected, other than the obvious?
There is the obvious,
Yeah.
of course. There is also within the orders that I've taken you to the fact that for the three stepchildren, Mr. Cooper was, and the only way I can describe it is, was ordered to be the linchpin in the organisation of the care of those three stepchildren. He was to be the go-between between the two parents. He was to be the person who arranged and managed handovers in order that the two parents who
Yes.
were at odds did not cause further harm to their children. That, I understand, was before Mr. Justice Sweeting. That, I would suggest, takes a step
Well, in
beyond
what-
the
sorry,
mere
I'm sorry.
failure. Forgive me, my lord.
What was before him? What was the page reference again? in
That
this?
is 165, my lord.
165.
Yes, it is an order. The order starts at the previous page on the 5th of August 2022, and at the bottom under H, handovers to be facilitated by the partner Mark. Mark is also to be the point of contact in respect of any issues which may arise around contact. It's a very small point I'm making, my lord, but the point is simply that it's not solely a matter of direct care and who cares. It's that Mr. Cooper was placed in a position by the court, I'm sure entirely rightly, to be the fulcrum around which the care for these children.
So it's obvious from that the making of an immediate order for committal would disrupt the relationships which have been prescribed by these orders.
Yes, my lord.
But if this sort of situation arises in the Crown Court, what happens in practice is that someone, probation, or if the person is privately represented, the person's other representatives, goes into the question of what would happen if there was an immediate order for incarceration. What other arrangements could be made? Is the grandmother available? Are there other people who could be paid to step in? What family resources are available? All those things are looked into and they're provided to the court, and then the Petherick assessment can be made.
Yes.
Was anything like that done here?
I don't know of any such thing, my lord.
There was no obvious reason why it couldn't be done.
No.
He had the resources available to do it.
I don't know, my lord,
But I
whether
suppose we don't know.
legal aid would stretch, legal aid on a contempt application would stretch that.
Well, this isn't
Because of course
legal
it's not.
aid. This is asking Granny if she can be available.
Yes.
I mean, shouldn't be overcomplicating it.
No, my lord. Forgive me, my
But
lord.
I mean, that's why I go back to the point that, as my lord indicated, this is the sort of thing that would be coming from the person at risk of immediate custody.
Yes.
I've looked at the report of Dr. Pilgrim to see how this dealt with. Clearly, he was performing a different
Yes.
exercise, but the most, in fact, probably the only assistance I think you might get from this is at page 150, at paragraph 684.
Yeah.
Which says what it says.
It does. You're talking about the first sentence, my lord. There,
Yes.
I take it. No, absolutely.
But in the end, I mean, really, we don't wish to press you, as it were. We just wish to satisfy ourselves that we're not missing some trove of information about how impossible the children's situation might become. Something that was shown to the judge, but which you say paragraph 31 doesn't adequately reflect at the moment.
I
There doesn't seem to
can't
be
put
any.
any such thing before your lordships. The only other thing I could properly point to, and again, this doesn't necessarily redound, no, in fact, necessarily isn't even the word, it doesn't redound at all to my client's credit, is the fact that up until he was committed, and Dr. Pilgrim's report, I would suggest, is fairly graphic in its detail of this, up until that point, my client had put himself, and I'm not saying it was anyone other than him, he had put himself in a situation where perhaps making these kind of other long-term plans beyond what he immediately had to do was something that he wasn't doing terribly well, given the sheer amount he was putting into his body at the time. But that's his fault. That's nobody else's fault.
Well, I know, but I mean, the difficulty with this type of situation is that looking at it from the point of view of the children and their mothers, for a lot of the time, reading Dr. Pilgrim's report, he seems to have become the 9th child.
Excuse me, my lord, could
He
you
seems to have become the 9th child. So the arguments that relate to how catastrophic the children's situation is going to be without him for a period of months have to be seen in the light of what he may have not or may not have been providing when he was there. But anyhow, we see what's.
I just wanted to be clear about this. On the written submissions by Mr. Uberoy appear to deal with this in paragraph 36 on page 100 of the supplementary bundle.
Thank you.
And I don't, but there's nothing there that really goes beyond what we've been able to extract from the documents usually and paragraph 31. So that I had understood that was the way it was being put.
That was the way it was put on the basis of these materials. And I would be misleading your lordships if I tried to provide things that weren't there. That is what was there. My point, and it's a narrow one, is only again, and I won't labour it because you've heard it, that where this extent of responsibility is concerned, perhaps a greater attention should have been paid, particularly to the question of whether anybody had thought about care. Now, I take your lordship's point that that's really Mr. Cooper's problem, not the court's problem. I'm not seeking to say
So the argument is not that there was an obligation upon the court to look behind the case that Mr. Cooper himself was putting.
No.
The argument is a different one, namely that on the basis of the case that Mr. Cooper was putting, the judge was bound to place greater weight on this factor and bound to deploy it to suspend the sentence.
Yes.
That's what it comes to.
Yes, my lord. And quite honestly, I think I think you have, I believe you have my submissions on that, and we've already covered most of what I was going to say about Turk, which was going to be brief in any case. The point is established, and Turk is just an example of it as part of ground, the only ground, as your lordship rightly put it, that this court may look at these circumstances, not that it must or that it is compelled to, but it is not prevented from doing so. If that's my learned friend's suggestion, I'm not entirely sure it was. Final thing I want to say, my lords, is obviously if and only if you're minded to give this point further consideration, minded to consider whether suspension is necessary, then the question arises, inevitably, of under what circumstances and conditions such a suspension could be imposed. There must be conditions, evidently, otherwise it would be bluntly a get-out-of-jail-free card. All I have sought to do at the end of my skeleton is suggest some possible conditions that would both act as the sword of Damocles, as it was referred to in Wilkinson, and also potentially offer some assistance to the claimants in the onward prosecution of the underlying matter. We've seen today, after all the problems that the prison is having producing Mr. Cooper for a Court of Appeal hearing, they also failed to produce him at a hearing 3 weeks ago. I think it was 3 weeks ago, in the underlying matter. That, in my submission, is a small but relevant part of the consideration of whether suspension actually potentially assists the claimants in this respect. Another part of that is, now that Mr. Cooper is clean and sober, and one could say this is the only aspect in which the current prison system has worked, it may be that he's able to provide information that he wasn't able to provide before. I don't know what that information might be. I hypothesize in my skeleton no more than that. So if my learned friend was misled into believing there was some underlying information of specific stuff that wouldn't be produced, then I apologize to him for allowing him to be misled in that respect. Nonetheless, it may be of assistance for a clean and sober Mr. Cooper to be able to pay attention to that. Also, of course, and this has been considered in Tonstate and Bond Turner, I won't take your lordships to the citations unless you want me to, and in many other cases, the pressure of, for a specific period of time, 12 months might be appropriate. Having the suspension sitting on top of him so that any future misconduct and failure to obey court orders would essentially result in a warrant of committal, an application for a warrant of committal, rather than having to go through the whole contempt procedure again. Those, I suggest, are not, as my learned friend seems to suggest, some form of horse trading that I'm indulging in, but simply an attempt to put before the court, should the court be willing to consider this, what would be sensible and pragmatic and helpful conditions to apply.
So paragraph 40 is where you helpfully set out what might be the terms of any suspension of
Yes.
the remainder of the order, namely at some point to provide further affidavit, and
Yes.
secondly to comply with any further orders that might be made in the underlying proceedings.
Yes.
All right. Is there anything else, Ms. Scotland?
No, my lord.
No, thank you very much indeed. Now, we'll rise at this point and consider where we've got to. Thank you.
All rise, if able. Will you come in first before they come in?
Yeah.
Okay. Just to let you know, the recording is still happening. This recording is still running. So if you have any conversations that you need to have, please take them outside.
We'll go outside, thank you.
And I'll let you know when.
Thanks so much.
Yeah.
Thank you. Just in a mind of my world around for 2 minutes. I suspect you're going to have a very quiet morning, Josh.
I don't know if they, I don't know whether they're gonna.
I don't think they're going to ask her.
Sorry. I know.
No point in being unrealistic
I'm
about it.
sorry. She'll be disappointed.
Oh, mate, I'm sorry. Should have insulted you or something. So.
Yeah, you should get.
I had a whole section about why paragraphs 5 to 23 were bullshit. He basically took that right out of my hands. I thought that might at least give you something to build on.
Yeah.
But right at the beginning, it was like, essentially, he basically told me that he wasn't going to look at them anyway. Yeah, we'll see. So your mum's actually watching live?
Yeah, I think so.
Oh, cool. I think my daughter would, but unfortunately she's in school.
Oh, okay.
Well, you sat very gracefully.
Sorry.
You sat very gracefully.
Yeah, I thought I'd been working on my posture. So,
Well, after 83 hours in transit in the last 3 weeks, you kind of need to.
yeah, we landed in Joburg just as England was going down to penalties.
Oh, Jesus, man.
Yeah,
On the way back.
yeah, but it was actually.
So when we were speaking, you were sitting in Joburg.
Oh, that was the
No,
following
so-
day. That was the following
yeah,
day. So
okay.
when I mean from St Leonard's to Joburg, and then the next day I was in the lounge when we spoke,
So,
and it was actually really fun though because it was the queue was full of English people. Everyone was watching on their phone, and there were kind of cheers and stuff going out. Yeah.
just you talk about watching things on your phone like that. But my sister's first marriage, this is like years and years and years and years and years and years and years ago, way before smartphones, was the day of an England rugby international, and I remember there were at least 2 tables where people had. You're too bloody young to remember this, but before smartphones, there were these little like pocket TVs with an aerial, like a transistor radio. And there were people with those on the table. It was like in the middle of the wedding reception, just watching the rugby on a screen that size. But obviously about that thick.
Yeah, I remember those things.
You're not old enough to remember.
I remember them. I don't think they were like in my.
His
I was-
grandparents had them probably.
No. I was a child.
You know, Josh, I've always loved you.
Yeah,
I was a child.
I remember them.
I didn't have one. I remember adults.
You remember their existence,
Their existence.
or are at least aware of them.
Yeah. I remember my first phone having an aerial, like a little one, not like a, it was a brick with a name.
I had one of the first Nokia Oranges, where there was the pull up. It was like a that big
Brick.
with the aerial that kept breaking off. I was living in a house where the only reception was if you leaned out the kitchen window.
I can't remember those had like that.
Still got the same number. Somehow. After the first decade, I couldn't really get rid of it.
I changed mine every couple of years.
Well, I used to be a reporter before I was this, so I knew to keep the same.
Court rise, if able.
Mr Hitchens, thank you for your submissions. We don't need to trouble you.
I'm grateful, my lord.
We've considered the submissions that we've read and heard. We will dismiss the appeal for reasons that will be given in due course in writing. Are there any other matters that we need to deal with now?
Not from me, my lord.
Thank you.
No, thank you, my lord.
In those circumstances, the order of the court will be that the appeal is dismissed with no order for costs and for reasons to be handed down in writing. The reasons will be contained in judgments that will be placed on the National Archive and on Bailey in due course.
My lord, I'm so sorry.
I just hadn't finished. In due course, that will be done electronically without the need to trouble the parties to come forward for the hand down. Yes,
My
Mr.
lord,
Hitchens.
I do apologise. When your lordship asked me whether there are any other matters, I thought you were referring to.
Very well. There's an
suggestion
issue
there
of
should be-
cost, is there?
It is, my lord. I'm sorry
Yes.
for not raising it. My lord, I'd ask for my client's costs to be assessed unless agreed.
Well, firstly, we don't make orders for assessment in one-day cases,
No.
in common with all other civil procedure. What are your costs and where is your costs schedule?
We don't have a cost schedule, my lord, for which I apologise. My solicitors were instructed very recently. They came on the record, I think, 2 days ago. So that's why there hasn't been an opportunity to prepare a cost schedule.
Well, I'm sorry, but that doesn't of course follow. 2 days is plenty of time to prepare a cost schedule.
I accept that, my lord.
Right. Anyhow, you want to pursue an application for costs.
My lord, I'd ask for costs in the sum of £15,000.
Right.
That being £2,500 for my solicitors.
All right.
costs.
So what are we to do now? We're to have an oral cost schedule because you're able to give us the figures that would have been written down had they been written down. Right. Okay. Well, let's not take further time at this stage about this, and we'll see where we go. But this is an oral application for costs, for which obviously, if we entertain it, Mr. Scott Joint will have an opportunity to respond in a moment. But give us the figures, please.
Is it my costs are £12,500, my lord? My instructing solicitors' costs are £2,500.
Yes, very well. And is that inclusive or exclusive of VAT?
It's inclusive of VAT, my lord.
Inclusive.
Certainly my costs are. Can I just have my back of yours? My solicitors' costs are exclusive.
Right. So what do? We add another £500 or something like that.
My lord, yes, it'd be £500 for VAT.
Right. So your application's for £15,500.
My lord, yes. This was an application which was advanced, and then the listing was delivered very shortly after the application was initially made. Therefore, there was an urgency to the preparation of this matter. There were a number of matters that were advanced in the appeal. I accept that one of the grounds was abandoned today, but nonetheless, everything had to be considered and responded to. These are long-running proceedings involving 2 contempts, which have inflicted a financial loss of approximately £3 million on my client. Therefore, it was an important matter for my client. And I say, in all the circumstances, the costs are reasonable and proportionate.
Thank you very much.
Your solicitors only came on board 2 days ago.
My lord, the notice of acting I have in front of me is the 9th of July. I apologise. The 9th of July that the
It's a long-running process, but they've not been involved in it.
they haven't, my lord, which is why the fee is weighted far more heavily towards my costs.
Yes.
The solicitors, of course, over the last 3 days have had to read a voluminous amount of material, get up to scratch for the appeal.
Sentence.
So, I'm sorry, my lord.
Not on the penalty.
Well-
Well, needed a voluminous amount of material to be considered on the penalty.
Well,
All we're considering is suspension.
I understand, my lord, yes.
And I accept that Mr. Scott Joint's made concessions today, but his revised grounds of appeal made it quite clear that that was the only issue, suspension.
I appreciate that, my lord. But obviously, initially when I was instructed, the grounds were slightly broader. They were the grounds advanced by my learned friend's solicitors. I accept, of course, that it's an error issue in this PLI, i.e. whether or not the
By
sentence
the
should be
time you
suspended.
did your skeleton,
Yes, no, the issue is
a very generous timetable was provided by me. By the time you did your skeleton, you knew that it was limited to suspension only.
By the time I did my skeleton, I did my Lord Jess. But in reference to my solicitor's costs, of course, I appreciate this appeal was limited to sentence, but you can't make meaningful submissions on sentence in my submission unless you understand the underlying conduct which is being complained of and the context in which it arose. So, my Lord, that's why I say it's appropriate for my solicitors to have read in detail.
Now, who are your solicitors?
Mackerel.
Right, so the court's record, which shows Ignite General Counsel as being solicitors, is outdated.
The notice to change legal representation was filed on the
bundle
9th.
where?
I'm sorry, my Lord.
That is in the bundle where?
My Lord, this was filed after the bundles.
I don't look at files, we look at the bundles we're provided
understand.
by the parties. So this is a document we haven't seen. Can you give me their name again then, please?
It's Mackerel
How do you
Solicitors,
spell that?
Mackerell. And that was filed on the 9th of July 2024, my Lord.
So, previously, because you've had involvement in this for some time, you were being instructed by in-house counsel,
Yes, my Lord.
and then on Tuesday,
Yes,
your clients decided to instruct
English solicitors.
English solicitors. This is not intended to be disrespectful to your instructing solicitor, who's here as he should be, but I'm not understanding in a sense what input he or they can properly claim to have in relation to resisting this appeal, because you've done all the work, you were here and ready to start. You had to be instructed by somebody other than the in-house solicitors. If Mackerels are going to be carrying on this litigation from here on, I quite understand why their team has to read it in order to know about it. But I don't understand what contribution, apart from the cost of attendance for a couple of hours today, is properly chargeable.
Well, I have to accept, my Lord, that the work had already been done, the skeleton being prepared, the bundles were agreed and filed. I don't think I can assist your Lordship any further.
Right, well, do you want to say anything about what the charging rate is for your client of your solicitor's attendance?
It's 420 plus VAT.
Right, that's helpful. Thank you. Anything else you want to say?
No, very grateful.
Thank you, Mr. Hitchens. Yes, Mr. Scott, are you in a position to respond?
Yes, my lord. We received a copy of the notice of acting. I'm going to deal with the solicitors first, and then
Yes.
I'll come to my learned friends part of the costs. We received the notice of acting at around midday yesterday.
Mhm.
It was personally delivered to my solicitor's offices and then sent by email as well. So we received it 48 hours after it was apparently, as far as we can tell from the papers, filed, less than 24 hours before this hearing. My submission on the role of the solicitors is very simple, because your lordships have already said it. I cannot see what value they have added to this process such
Well,
that
could
it's
we-
reasonable and
let's assume we retracted by that
yes, then I won't say any more.
submission. Speaking for myself, it seems to me that it's a proper courtesy that a representative of the firm should attend counsel at a Court of Appeal hearing.
My lord, I can't disagree with that. But beyond
So
that,
what do you say in relation to attendance fee for the appeal, which, as it happens, is going to finish by midday, but might well have lasted until midday?
I don't know what band Mackerels would fall in. I haven't had a chance to check that. I can't therefore say what relation 420 plus VAT might have to a proper charging rate. I'm not entirely sure which grade the solicitor
Well,
would
if you're
fall in.
happy
I
that-
can't really argue that £400 odd an hour is unreasonable for a sensible solicitor in a Court of Appeal matter, so I'm not going to try to. I would suggest that since this was always, in my submission, likely to be a relatively short hearing because it is a exceptionally circumscribed grounds of appeal, that no more than an hour or a maximum of an hour and a half is really reasonable for attendance this morning, and nothing beyond that, given, as I've said, it's hard to see what additional reasonable and proportionate value has been added.
All right. Well, your learning colleague's brief fee provides you with a larger target.
It does.
What do you say about that?
Again, I'll keep it short and I'll keep it simple. Your lordships made clear early on and that this was a narrow situation. It did not require more than a relatively narrow approach. It didn't require extensive perorations about the nature of the underlying contempts or the underlying litigation. It didn't require anything to do with the actual length of the sentence and whether that was justified or not. I'm going to suggest that my learned friend's work, while no doubt excellent, was excessive for the specifics of this case, and he has known from well before he will have started writing exactly what the grounds of appeal are going to be. Those will then not have, the revised grounds, those will then not have come as a surprise at the point when he was doing the preparation. I'd also point out that, of course, the work of preparing bundles, of providing materials for this court, has all been done by my solicitors. My learned friend has been exceptionally helpful in helping identify documents that are needed, and I appreciate that. But that's not that much. And under the circumstances, I would suggest that his brief fee is also not excessive for him, but excessive in costs for us, given the nature of the matter.
Thank you very much.
I'm obliged, my lord.
All right. Nothing else.
No, thank you, my lord.
No, thank you very much. Well, we'll rise and consider this.
Court round is disabled.
Surely VAT doesn't apply because your client is in the US, so they don't pay.
That's quite right.
But it's Ignite Brands UK
Yeah,
Ltd.
so there was one company in the UK.
Which is
So they were being
very,
charged.
very annoying for our purposes. If it was a Swiss company, it would have been different.
Annoying for your purposes. Oh yeah, the first respondent is brackets UK Limited. Isn't it? Yeah, fair enough. How's where's it go? Sorry. Not 500 quid off the top. I think they'll give me £5 or something. Oh no. Oh no.
It would probably be a straight 10 or something like that. In total, I think we'll give that 10. But
Yeah, no more than 15's a stretch. 15 and a half, that is. Not sure.
Court rise, if able.
Although there is no schedule of costs as there ought to be, for reasons of practicality, we are prepared to deal with this on the basis of the oral statements that have been made to us by the respondent and to assess the costs payable by the appellant. We assess the costs to be payable in the sum of £4,000, inclusive of VAT, broken down in this manner: £1,000 inclusive of VAT for the fees of mackerel solicitors, on the basis that we are grateful to them for attending council today in a very proper way, and would make allowance for some 2 hours of attendance, and at the charging rate we were notified of adding VAT, that amounts to, in round figures, £1,000. They will appreciate that they wouldn't wish to be charging for more than that, in particular for reading into the case for any future work that may or may not need to be done. We assess a reasonable amount for the appellant to pay for counsel's fees of the respondent in the sum of £3,000 inclusive of VAT, not by means of any wish to comment upon, still less criticise the amount that will in fact be paid to council, but to take account of the submission made by Mr Scott Joint that what is necessary for us to consider is what it is reasonable for the appellant to pay of that amount, and we have in mind when reaching that conclusion the fact that the role of a respondent on a committal appeal relating to only one aspect of sentence was always likely to be very limited. So therefore that is our costs order. Would council please draw an order reflecting what we have done, and we'll let you have our written reasons and judgments as soon as we possibly can. Thank you both very much.
Court rise, if able.